Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Temp check. What kind of summer are we having this year? A family road trip summer? A beach bum summer? Or a wake me up when the sun sets summer? With Instacart, choose your own adventure and skip the shopping side quests. Where available, you can get ice cream delivered to your hotel, sunscreen to the pool, or cold brew to your bed. Well, door, in as fast as 30 minutes. Wherever you find yourself this summer, you can get the goods. Download Instacart for free delivery on your first 3 orders. Offer valid for a limited time. Minimum $10 per order. Excludes restaurants. Additional terms and fees apply.
Okay, it's time to commit. 2024 is the year for prioritizing yourself. Begin your new smile journey with Byte, and you could start seeing results in just 2 to 3 weeks. Just order your at-home impression kit today for only $14.95 at Byte.com. Byte clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces. Plus, they offer financing options, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning, this episode contains discussion of the murder of 2 girls. This episode also contains discussion of suicide.
So this week begins for us all with several new filings in the Richard Allen case. There's actually filings from both the prosecution and the defense, and they pertain to some pretty important issues. The issues that have been at the heart of this case for a while now, namely, where should Richard Allen be housed and who should preside over the case? We're going to talk about these filings, try to figure out what they say and what it all means.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders, the defense's verified motion to disqualify, and the state's response to defense's motion for transfer.
Let's start by discussing the defense's motion to disqualify. The first thing to note that is it is essentially in 2 parts. We have their actual motion, and then we have an affidavit from Richard Allen. And of course, what the defense is doing here is they are asking for Judge Gold to be disqualified or recused or removed from the case.
Should we look at the verified motion to disqualify as perhaps more of the legal argument of this, of what the standard is, what should happen, what the legal expectation should be, and the affidavit as more of the Frank's memorandum to that?
Yeah, more or less. That's a good way of looking at it.
Right. Because the legal stuff's always going to be more relevant in a situation like this.
And let's look at the legal stuff first.
Yes, I think that's
because this is, for all intents and purposes, what the defense is doing here is basically trying to set up, here are the rules we should follow when deciding whether or not Judge Gold should be removed from the case. How do you make this decision? How do you come to the conclusion that someone should be removed from the case? Where is the burden of proof? What is the standard?
Absolutely. So they want to establish that, make their arguments, bring up their examples, and then go from there.
So what do they say?
They say that they cite Indiana criminal rules of procedure, a number of them, and note that what they're establishing is that they feel that if a rational, normal, reasonable person who's coming into this non-biased, they're just, hey, what do you think about this? If they think that there would be inherent bias in the proceedings, then the judge should be removed.
Yeah, they say you don't have to prove that Judge Gold is actually biased. They're saying all they have to do is come up with information or arguments that might make a reasonable person say it's possible she's biased.
So in some alternate universe, if Kevin is a judge and I'm a defense attorney appearing before him, would a reasonable person be concerned about bias because we are, in fact, a married couple? And the answer is yes. Doesn't matter how wise and professional that Kevin is. In that situation, a reasonable person can say, this seems inherently problematic. It's kind of a stupid example because I imagine things would never get that far as far as but maybe if we concealed our relationship, that would be something that could be a problem down the line because it would just show an inherent bias. Even if Kevin didn't necessarily make any rulings that seemingly were unreasonable, I think that's the sort of thing that would just be inherently problematic. So the defense is arguing that because Judge Gull threw them, in their words, threw them off the case.
That's just one of the things that they...
Well, that's a big thing.
That's the big thing.
It's sort of like, you tried to get us off the case. You wanted us off the case. You expressed that we were incompetent and negligent. That makes you biased. A reasonable person should be able to see that. So therefore, our request for a recusal should be granted.
Yeah, they make the argument. That's the big thing. Everything she does from now on in the case is going to be seen through that lens. She essentially has made public her determination that Baldwin and Rosie are negligent and incompetent. So the argument would go, how can she be seen to be a neutral arbitrator?
Right. I will be super curious to know more about what is the standard? Is this a fair representation of the standard as it typically plays out in these situations? Part of the problem with evaluating this is I imagine this is relatively rare. A lot of this sort of is happening in a way that's not typically the way things play out. So I'll be curious, what is the standard that typically happens?
And near the conclusion of this particular document, the defense attorneys ask some questions, which I will now read. Will Judge Gull's continued involvement create built-in reversible error in the event defendant Allen is convicted of any one or more of the charged crimes. Will all future rulings of the court be viewed by the defense as being tainted with bias, prejudice, and a lack of impartiality? Will the public be able to maintain any sense of confidence that the presiding officer, Judge Gull, is unbiased and impartial? Can Judge Gull process any information and or legal arguments offered up by attorneys Rosie or Baldwin, knowing that she has already made an extrajudicial finding that both attorneys have demonstrated gross negligence and gross incompetence in their representation of defendant Allen? Does Judge Gull have some ulterior reason or motivation driving her unwillingness to recuse herself from this case? Do the practical benefits of recusal far outweigh the inherent risks of Judge Gull remaining on the case, especially as it relates to the likelihood of protracted and expensive litigation throughout the remainder of this case and in the appellate courts if a conviction occurs? So they're saying if she stays on the case, not only is that going to look bad, but that's going to create reversible error potentially, where if he is convicted, there can be appeals, that everything can just drag on longer and longer and longer.
And that they will keep fighting it. I mean, what they're indicating here is throughout, expensive litigation throughout the remainder of the case. So it doesn't even have to wait until post-conviction. This litigation, the indication is that, they'll be bringing it.
Yeah.
So I think that's kind of a clue or a forecast of how things will go going forward, at least as far as the defense is concerned, prior to trial. One thing that some people might find interesting or confusing is this document, the verified motion to disqualify, as well as the affidavit of Richard Allen that goes along with that. Both are signed by Richard Allen at the end. Does that mean he wrote these?
No.
Yeah. Can you explain that?
When you have an attorney and your attorney is representing you and preparing legal documents on your behalf, it's perfectly normal and customary for you to sign them. He's not saying, by signing this document, Richard Allen is not saying, I wrote these. He's not saying, I wrote every word of these. He's basically saying, what's in here represents my thoughts and beliefs. So I endorse this, is what he is saying.
Yeah, I wanted to single that out because I think sometimes people kind of look at stuff like this and they're like, the defense attorneys are saying he wrote this whole thing. How fraudulent. This is pretty standard.
Yeah. So speaking of the affidavit of Richard Allen, why don't we jump to that now?
Yes. Before we get into the meat of this, I would divide this, 22-page document into two categories. Basically, it's a list of all the things that
Judge Gull has done,
yeah,
or is said to have done, that would create the appearance of bias that might make a reasonable person have doubts about her capacity to preside over an impartial trial.
And I would divide these into two categories. One is items that directly have to do with the legal issues spelled out in the verified motion that get into sort of what is a violation of Indiana Code of Judicial Conduct or the criminal rules of procedure. That's one category. The other category appears to be relitigating older, you didn't rule in our favor for the safekeeping order, so you're biased. So it's interesting. And I think that's something that characterizes the old defense team, is that there's an element, they could basically use anything, and regardless of whether it's worked or not in the past. I think that can characterize some criminal defense attorneys in general, because you want to use anything in your arsenal.
Yeah, if you have any possible argument, whether it's strong or weak, you don't want to leave anything sitting on the table. You're going to use whatever argument is available to you. And you just hope that if I come up with a list of, say, 15 arguments, maybe there's 7 or 8 of those arguments that people will find compelling. I'm not sure which 7 or 8 items will do that, so I'm going to include all 15.
Yeah. Do you risk, as an attorney, ever including something that's too weak and it tanks your case, or is it typically just you want to play the numbers game?
I think you want to play the numbers game.
Yeah, makes sense. All right. Well, that's definitely what that comes across strongly in this document.
So yeah, I think most people reading this might find some of these points a lot more compelling than others.
Yes.
But that's to be expected. So in this affidavit, defendant Allen, through his attorneys, is Anya said, is listing reasons why Judge Gull's ability to preside over this trial should be questioned. The first one, Judge Gull interfered with Richard Allen's attorney-client relationship.
So she ordered them to cease work on October 12th, 2023. What they're saying is she violated his rights under the state and federal constitutions, and also she, there's a lot of the premeditated removal of Rosie and Baldwin. So that definitely leaning into the version of events where they were forced to withdraw and coerced rather than made that strategic decision.
Number 2, Judge Gull publicly and on the record disparaged defendant Allen's chosen attorneys. This was the hearing where she said the attorneys were grossly negligent and acted with gross incompetence. The argument there, of course, is that if someone says basically, Anya, you're a bad person, you're a bad guy, how can that person be expected to, in the future, act with impartiality towards you because they have already made up their minds about you? That would be the argument.
Right. And why is that so important when it's coming from a judge, as opposed to someone just yelling at me in the street?
Which happens on a daily basis. The argument is this judge is supposed to be totally impartial. The judge is, to a certain extent, supposed to be like an umpire, calling balls and strikes in the courtroom. It's not supposed to have formed conclusions about the abilities of the players.
So if the umpire is umpiring your beloved Cubs and stands up in the middle of the game and says, "The Cubs suck.
The Cubs are negligent.
I have no respect for any of you. You are all bums." Then that would be, a problem.
And then, yeah, after that, if the judge says, "I hate the Cubs," anytime the umpire would make a call against the Cubs, I might say, "Hey, wait a minute."
Kevin might be a bit concerned. So that's what they're sort of characterizing this as, is basically these public disparaging remarks, these, the actions on the record all speak to something that's kind of insurmountable.
And there's a fun footnote here. Sometimes in these legal filings, the attorneys like to needle each other over things that have happened. I think we all remember that in the oral argument, Judge Gull's attorney, Mr. Gutwein, made the comment at one point that, well, yeah, Baldwin and Rosie are very competent, except now in this case. So there's a footnote about that saying even the Judge Gull's attorney was acknowledging that these are competent people, except in this case, that's kind of hard to reconcile the two. And so if even her attorney is suggesting they are good attorneys, maybe that in itself is also a show of bias.
Right. So that's giving them ammo. We had some commentary about this in our Facebook group, and I answered it, and I had a specific opinion, and I'd be curious if you have a different opinion. So people seem to take that exchange of Gutwein saying something positive about them as like a fatal flaw, something, that totally torpedoed his argument. I didn't really feel like it was that. It was kind of amusing from the perspective of like, why would you say something nice about them if you're Gutwein? But from my perspective, what hampered Gutwein was more of overly relying on the Wheat case and taking such a procedural argument when the justices were clearly more interested in it than just having a procedural excuse to hand wave it away. To me, that the arguments weren't really about whether they were competent or not, because he was just couching it in such a procedural way. And it's not people I think sometimes mistake stuff that sounds interesting to us with something that would sound interesting to the justice, because there's not really any like legal bearing on what he's saying. I don't know. That was just my take. What did you think?
I'd agree with that.
It's more color than anything.
Yeah.
But as you said, it's good needle.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
What makes a life a good one? Is it the adventure you have? Or the friends you find along the way? Maybe it's pursuing your passion while striving to protect, defend, and save what you believe in every single day. So, what makes a life a good one? In the Coast Guard, we think it's all of the above and more, but you'll have to find out for yourself. Visit gocoastguard.com to learn more.
So let's get back to this document. Item 3, Judge Gold violated defendant Allen's due process rights. What's the argument they made there?
So the argument that the defense makes in this section is that, so they characterize October 19th, 2023 as Gull giving them a, quote, Hobson's choice, which means an impossible choice. And the choice was what they say, suffer a public shaming, which would hurt Richard Allen, and be removed from the case, or to voluntarily withdraw and avoid compromising his defense. And so they feel that she, by doing this, by structuring the choices in this way, she did not give them due process to, refute or address or talk about her accusations against them as far as them being grossly incompetent, grossly negligent.
And again, to some extent, that's already been litigated, but I think the argument again here is that this is meant to suggest or prove that she's biased.
Like, if you weren't biased in this situation, why didn't you have a hearing where you could all present evidence?
Yes. Item 4. Judge Gull engaged in critical stage proceedings in defendant's absence. This is the fact that the critical meeting took place in the judge's chambers outside of the presence of Richard Allen himself. And that was a violation of his rights. And so therefore that again allegedly shows bias.
The next one failed to maintain impartiality and fairness. You're probably getting a sense that a lot of these different subsections sound very similar, but they're each addressing, I think, subtly different elements of what happened. So this is another one of the ones that focuses on October 19th, 2023. And it says that by describing the defense counsel's work as having inaccuracies and falsehoods, specifically around the safekeeping order, that, she's saying she's biased.
Number 6, Judge Gold demonstrated bias towards the prosecution. This is a reference to, we've all heard that there was a phone call where the leak of crime scene photos was discussed. Judge Gold asked, what do you think should happen? Prosecutor McClellan says, I think they should be taken off the case. And Judge Gold immediately agrees or indicates that that's also how she thinks. And the claim here is the fact that she made that conclusion immediately without a hearing, without research, is also evidence that she may be biased against Rosine Baldwin.
So the next one, which is point 7, Judge Gull made public misrepresentations on the record. What they are saying are the public misrepresentations on the record is the fact that she referred to their withdrawal as an unexpected turn of events. at that hearing that lasted 4 minutes.
And so the argument is that's not what happened. It wasn't. She said it was unexpected, outside our control. They say, well, actually, it was fully within Judge Gold's control.
And in addition to that, they go into the wrangling over the transcript around the in-chambers meeting and the back and forth over that, I guess.
Number 8, Judge Gold engaged in ex parte communications.
What is ex parte communications and why is it a problem?
Ex parte communications is where attorneys on one side of an issue or one side of a case have communications with the judge outside the presence of the other side.
And that's very much not allowed, correct?
Yes.
Like, that's pretty serious.
And they're saying that Judge Gull in particular had text communications with Librado and Scremin outside the presence of Baldwin and Rosie. I guess the argument would be made on Judge Gull's side that at this point maybe she assumed that since Baldwin and Rosie were no longer on the case. I know it gets complicated, but the implication from the defense is that she was treating them with disrespect and not according them the rights they were entitled to as Allen's representatives.
The next one, 9, is Judge Gold denied defendant Allen his Sixth Amendment right to counsel, and doing so denied his right to a speedy trial. Here's where we come back to the speedy trial element of all of it. But they're basically saying she violated his Sixth Amendment rights by forcing them to withdraw, and then also not letting them back on as pro bono counsel. And in addition to that, they still claim that Richard Allen's intentions were to file a speedy trial motion, and want because he wanted the January 8th, 2024 trial, and that by knocking his Sixth Amendment rights, she made that impossible.
Number 10, Judge Gold changed her ruling in a prior order when attorneys Rosie and Baldwin were reinstated. So this one is a bit more complicated, but after attorneys Scremin and Librado came on the case and represented Richard Allen officially, Judge Gold issued an order, or whatever you wanted to call it, in which she indicated that if Scremin and Librado filed a motion that they were interested in adopting the Franks memorandum as their own, she would schedule a hearing to make a ruling on it and to gather evidence. But then as soon as Rosie and Baldwin come back on the case, within days, she issues an order saying there's not going to be a hearing on this. So the implication there is she dislikes Rosie and Baldwin so much that she's going to rule against them and deny them a hearing, even though she was prepared to offer a hearing to the attorneys she liked, Scremin and Librado. And the argument is that's a pretty good case for bias.
So point 11, Judge Gold discredited defendant Allen's defense strategy. So this goes back to the Franks memorandum and the Franks hearing again. So they note that was those Franks documents were filed on September 18th, 2023. And then Gull, when Scremin and Librado came on, she advised them to adopt those pleadings or make their own. And what defense is saying about that statement is that by giving Librado and Scremin the option to walk away from the Odinist theory, she was saying that it wasn't important and therefore she's skeptical of it. I guess it's treating the Odinist theory with not enough respect that it deserves, in their opinion.
Point 12, Judge Gold committed violations of the Access to Court Records Act. This is something that also was discussed at the Supreme Court, not in oral arguments, but in some in a
The separate writ of mandamus.
In the separate writ of mandamus, Judge Gull removed documents from the case record, shielding them from the public, things like the Franks memorandum, and that by taking documents that spell out the defense's case out of the public's purview, she is acting against the interests of the defense and therefore demonstrating what the defense team sees as bias.
So, Part 13, Judge Gull engaged in additional violations of access to court records. So this is like, I guess, a continuation of the part Kevin just said. And that deals with specifically her decision to strike Rosie's filings from the record. So after he was withdrawn, she argued he's not really an attorney, so these don't count, and removed them from the docket. Eventually, she reinstated them after a writ of mandamus was filed.
Point 14, Judge Gull failed to address her administrative duties.
So now we get to the money.
I think this might hit home for a lot of people who've worked freelance jobs and have had to turn in requests for payment. The claim here is that attorneys Baldwin and Rosie have filed proper requests with the clerk of courts to be paid for their work, and Judge Gull's and her team have not acted on them in a prompt manner, forcing the defense attorneys to have to wait months to get paid, and then only get paid after they really have to work to get the judge to approve their invoices. And then again, the argument is this demonstrates bias against them because she's not acting in a more prompt manner.
Interesting standouts from this section include a sentence when they say that Baldwin personally sent an email to Judge Gull's staff essentially begging to be paid. So they argue that this issue started around May 19th, 2023. Baldwin submitted invoices. Things were not paid. Then he was paid completely on September 18th, 2023. And that was a few days after Judge Gull gave the order to Carroll County. The defense attorneys note that the Carroll County people were more communicative. The auditor said that they would pay the bill, but they needed an order from Judge Gull. And so they were waiting on that. And in addition to that, that was 4 months after the bill happened. And Rosie had a similar experience. He submitted his stuff on May 10th, 2023, and that was not paid until September 19th, 2023. More recently, Rosie said he submitted 2 different invoices for his own services and also for his administrative staff services, administrative expenses, actually, on October 4th, 2023. And he kept emailing the staff saying, here's all that you owe me. But those ones haven't been processed yet. And what they're saying is that some of those invoices were paid, but Rosie's 2 invoices are not. And they're saying that by not paying them, that she's showing bias against them because she's, depriving them of their income. The next one is 15. Judge Gull failed to protect the accused. So this kind of relitigates the emergency motion to modify the safekeeping order, which was filed, of course, on April 5th, 2023. And they say that she was too slow to do a hearing, given that it was an emergency, and they said so in the title, on June 15th, 2023. They say that she did not force Westville inmate and convicted child molester Robert Bastione to come to that hearing. He was supposed to come. He was subpoenaed. He refused to leave his cell, claiming that he was scared to. And what they argue is that he should have been forced to come.
Or in lieu of that, there should have been a hearing on the issue.
Hearing where everyone decides what to do, because he didn't have a choice in the matter.
Yeah, they're saying that Judge Gull essentially ruled against them on the motion, saying they had no evidence, but at the same time, perhaps Bastone could have offered evidence that might have bolstered their case, and she did not force him to come and testify.
Yeah.
So again, the argument there is that all of this shows bias on
because
her
it
part.
ignored their subpoena, and it was a refusal of a compulsory process. We've noted in past episodes about Bastone's crimes and his credibility issues, but what they're saying is that, leaving all that aside, the process should have been different.
Point 16, Judge Gull's continued and ongoing failure to protect the accused. And this is, again, referring to him being housed in Westville or Wabash as opposed to a jail.
17, Judge Gull has treated the prosecution more favorably than the defense counsel. So the classic, she likes them better than us argument.
The big thing there is they are complaining that Prosecutor McClelland had this letter from Todd Click in which Todd Click discussed his views about the real perpetrators of this crime being Odinus. He had this letter for, I believe they say, a period of months before turning it over to the defense. And they say that McClelland was never chastised or criticized by the judge for not turning over the Click letter more quickly. And that indicates bias in their view.
They also continue to use the word Odinite, which is, our friends from the Troth have told us, is a rock. Not, these are Odinists that they're talking about. So just keep that in mind when you're reading these. Odinist. Now I just flinch every time I see the word Odinite.
Point 18, Judge Gull engaged in unacceptable extrajudicial activities.
Now this is interesting because this is some new stuff. We saw a lot of relitigation and stuff that you would imagine because we've all seen we saw what happened on October 19th. We've seen the debates. We've seen everything. We've seen the drama around safekeeping and Franks. But now we're getting to Facebook.
Why don't you tell us about this?
So July 9th, 2023, they describe this person as someone who's believed to be Judge Gull's then daughter-in-law. Okay. Published an entry on this former daughter-in-law's Facebook page, and this was the post. What an honor it was for the girls to play in the Abby and Libby Memorial Tournament. What a greater honor it was that Abby and Libby's grandparents presented our girls with their championship finalist rings. Apparently on this post, Judge Gull commented, "Congratulations." So you may be wondering what's going on there. And the defense does note that it appears to be innocuous, but they are saying that it raises questions about bias because I guess her relative had a positive interaction with the grandparents of the victims at some sort of sports tournament. Is that what you're reading?
Yeah,
here?
I guess the implication is that there is some sort of relationship between witnesses in this case and Judge Gull's family that Judge Gull is aware of and encouraging and support. And that said relationship could be used to call her impartiality into question. And that is me trying to read this argument in the way most favorable to the defense because they're the ones making it. That's how I interpret it. Is that how you understand it?
I think a lot of people might wonder about how strong that is. Just seems like there's a lot of, it's sort of, I wonder if other jurists would take that as a nothing burger or would take it as a concerning post.
And again, all we need, all the defense says they need, is for the appearance of impropriety, something to make a reasonable person wonder. And if you had a case before a judge, let's say we have a bitter professional breakup and personal breakup.
That's sad.
And the judge is commenting on Facebook posts of my relatives about my grandparents and how great my grandparents are and how great the Greenleys are. You might wonder.
I just think that they were being accurate. No, I'm just kidding. Yeah, I think, and also this speaks to what if I keep my list about how much you're biased to like 3 of my strongest points. On some level, people might look at that and say, okay, but it's like the only 3 here. But I think a long list of, a dozen plus, even if not all of them are winners, it's still, in the eyes of people, you're still making almost a better case for yourself because you're like, boom, 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 boom.
And also, when you've talked in the past about the case against Richard Allen, you talk about how maybe some of the individual pieces of evidence against him may, in and of themselves, may not be conclusive. But when you pile them up on top of each other, it eventually potentially creates an argument for guilt.
Yes.
And so you could apply the same reasoning here. That if you go through this document and you can say, well, I don't find this one too compelling, I don't find this argument too compelling, but taken together with everything else, you could argue, if you were the defense, it creates a picture.
And I think it's important to differentiate that, though, between the Franks memorandum. I've been somewhat critical of the Franks memorandum, including things that I felt were a bit weaker than maybe the fundamental arguments, right? And or pieces of evidence that didn't really pan together. But in this case, they don't have Judge Gull on tape saying, I'm very biased against the defense and I think, I'm going to destroy their case. There's no like concrete evidence. What all they can do is create an impression and document what they feel is an impression. And so it makes sense in that context to proceed in this way and include as much as you can, in my opinion. I think that's a strategic move that makes sense. Point 19, timing of judicial bias, prejudice, and lack of impartiality. So this gets more into the legal stuff. So they're talking about how Allen, this gets into like rules around timing. They're saying Allen basically didn't really notice the bias and the idea of the bias codified in the minds of him and his attorneys during the phone call between McClelland and the defense attorneys and the court on October 10th, 2023. They say that some of the issues that they disagreed with her about in the past, they didn't really want to think as bias, but now looking back, they think it's bias. So I think this gets into why this is basically getting into why this was filed when it was filed, why it wasn't filed prior.
Yes.
So they're saying this is why, because we needed to come back on the case and all this stuff happened and we didn't have, so this is more of explaining the timing. And so then it's signed January 27th, 2024 by Richard M. Allen.
So shall we move on and discuss what Nick McClelland filed today?
Yes. Do you want to start with the state's motion to compel discovery? So let's start with the state's response to defense's motion for transfer. This is a very interesting document.
This is a very interesting document.
Yeah.
Can you remind us what he's responding to?
Well, sort of it's like chains have formed in the case that kind of like, there's these different kind of channels that kind of, different issues that kind of keep coming up. And sort of, so this is very much a link in one specific chain around Allen's housing. Where is he supposed to be located while he awaits trial? The defense has argued strenuously that he should not be incarcerated in the Indiana Department of Correction, aka our prison system here. They say he should be in jail in Cass County or somewhere else. Carroll County it would have been the obvious choice, but they say that they don't feel like they can safely protect him because it's too high profile a case. And so he has been moved to Westville and recently Wabash Valley. So what McClelland is specifically responding to here is Robert Scrimmin and William Labrato filed something a while back saying that they tried to visit him in Wabash Valley. They ran into so many issues. They were not allowed to do this or that. And it was, they're basically arguing that his rights are being disrupted and kind of giving some comfort to what the original defense team was saying. So it was like, okay, so these new attorneys are having similar issues. This is interesting. And McClelland's role in this has always been to basically say, we don't care where he is. We don't care. But you're presenting misstatements and inaccuracies in your filings.
Yes, he says today exaggerations and inaccuracies are in the Scremen filing. So basically he's saying Scremen was lying.
Yeah.
That's not the legal term, but that's basically when you're saying someone is putting in inaccuracies and exaggerations, you're saying he's lying.
And he gets into some, what he's saying is evidence to support the argument that Scremen was not entirely accurate or honest in his filing recently. Before we begin, this boils down the thesis. This is point 12 in the document. Basically, this is what he's saying. The state has no opinion where the defendant is housed during the pendency of this case as long as he is kept safe. However, the state believes that it is imperative for the court to have accurate information in order to make its decision, which is lacking from the defense's motion to transfer.
And then he goes through and starts talking about the points that he says are exaggerated. We just talked about Robert Bastone, the child molester who claims to have evidence supporting Richard Allen's claims. McClelland said, this guy's never been subjected to cross-examination. He's not a reliable witness.
Yeah, I mean, to be clear, this is a man who continues to deny the fact that he molested a 6-year-old girl, despite the fact that his DNA was found all over her. He says that was an error at the Indiana State Police laboratory. Lab errors happen, but a lab error does not explain why the 6-year-old girl identified him as her attacker and why he left a pool party with her and then returned with her crying and her bathing suit all dirty. So one thing you should also know about Bastone is that he is frequently victim blamed this 6-year-old, indicating that she didn't really act like a victim. So his credibility is non-existent, in my opinion. I think it's surprising that he's become such an important player in this case. I think that prison house snitches and jailhouse snitches should always be looked at skeptically, whether they be being used by the prosecution, which is typical, or in this situation, the defense.
McClelland says that in this filing, they repeat the claims that Richard Allen is being mistreated by guards at Westville who practice onanism. He says this was already addressed previously, and there's been no evidence to support that.
I want to throw one thing about onanism, and this is something we've talked about with folks at the Troth recently. That's an inclusive group of heathens. So let's all keep in mind that there's different types of heathenry. There's heathenry, which is a general term, which is people who practice essentially Norse Germanic pagan religion. It's very diverse. There's a lot of range within that. But you can have inclusive heathens who are not racists. They're just normal people trying to do their thing. They're not bad people. Don't be mean to them. There's nothing wrong with being a heathen. Then we get into a Satru. That is more of an exclusive form of heathenry. They believe that you really should be of Norse descent and white, so racist. That is a racist ideology, but it's not necessarily associated with any sort of violence or gang activity or anything like that. So it's problematic, but that's a different thing. Onanism is specifically very much white supremacist, very much politicized, very much connected with prison gangs and activities, and violence. Mostly political violence, but violence nonetheless. So these are 3 disparate groups. And to my mind, labeling anybody who might have Norse symbology around them or have that be a part of their religion as Odinist is really not necessarily accurate. Odinism being a specific thing, I think you need something a bit more than just saying here are symbols that are relevant to all heathens. And so one thing that's been so concerning to me is just the flattening of this language and labeling everybody in a certain religion as the most extreme and awful form of that religion. I think we can all understand why that's an uncomfortable thing for the defense to be doing. And I would hope that if they had evidence of the Odinism thing, that would be something that would come to the forefront soon, because I feel like, I don't know, I have a problem with labeling people to that extent. And I don't think that that's been proven that these guards are Odinists. I think heathens, sure, but as we stated, that can be a good thing, a normal, neutral thing, that's just their religion, or it can be something where it is inherently problematic, maybe not even relevant to Richard Allen's case, but I mean, if there's a white supremacist thing, then that's going to be a concerning thing for a guard to have in a prison regardless. So I guess I just feel like there's been so much ink spilled over that, but not a lot of clarity.
Well said. McClelland also says that in this motion, Scremin claims that Richard Allen had been denied recreational time. He says the only time he was denied. In response to that claim, McClelland says, when the defendant was moved from Westville Correctional Facility to Wabash Valley Correctional Facility, he made statements about committing suicide. As a precaution, he was examined by mental health professionals, and they determined that he should not be given recreational time until they could be sure that he would not hurt himself. Once he was off suicide watch, his recreational time resumed.
Okay, so we're hearing once again about suicide watch, suicidal ideation.
So he's saying that if he was denied recreational time, it was just during the time period when he was on suicide watch, and he was on suicide watch based upon his own comments about wanting to commit suicide.
Also, he was on suicide watch very recently, if that was between the Westville and Wabash Valley transfers. So this has been an ongoing issue, apparently. That's concerning.
In their recent motion, the former defense team of Scremin and Librado also said that the check-in process at Wabash Valley, when they went to see their then-client Richard Allen, was too burdensome and time-consuming. Here is McClelland's response to that. The state was able to review video footage from counsel's visit with the defendant in Wabash Valley Correctional Facility. Counsel for the defendant arrived at the facility at 12:35 p.m. and were processed to visit with their client by 12:58 p.m. That the wait time was extended on this date due to a power outage at the facility, but in total it lasted about 23 minutes, not the nearly 1 hour alleged in the pleadings.
How do they account for that? Did it just feel like an hour?
You'd have to ask Scremin and Librado.
What do you make of that?
I don't know.
That's shocking to me. That's shocking to me that there's such a discrepancy.
Yes. McClelland goes on to say that Wabash Valley has done what they can to accommodate the attorney's ability to confer with their clients.
He says that normally face-to-face visits are not even allowed at this facility. So the implication is the fact that Wabash Valley even attempted to have something for the defense attorneys.
And they made accommodations for the defense attorneys to be able to share discovery materials with Richard Allen, and the attorneys did not bring any computers or anything with them for that purpose.
And why is that important that they didn't bring any computers or anything with them?
Computers are something you could use to share discovery material.
So, yeah. That's, and it says if they had wanted to, there was a slot where documents, papers, or what he says, whatever, could be passed back and forth. So, neither attorney brought a computer with them to provide defendant with review of video or audio discovery, even after DOC made accommodations for them to do so. One thing that has also come up a lot is the filming of defense attorneys in this case when they're visiting Richard Allen.
Yeah. And McClelland says the only filming was motion detectors, so there's like footage of the attorneys entering and leaving the room.
That is for safety reasons.
Yeah.
That is something that we have heard from other defense attorneys and people who work within the correctional system, that there can be film, but often it's not audio recorded. It's just to make sure that nobody gets attacked or nobody tries to commit suicide. And he knows that each request that the counsel for the defendant has made of Wabash Valley Correctional Facility has been granted, and that basically what he says, the allegations are exaggerated and misleading. What are your thoughts on the discrepancy between what Scremin claimed in his filing and what McClelland's assessment of the evidence is.
It's very reminiscent of the original filing and McClelland's response to it. And I guess it's hard to make a final determination until we see if Scriven and Librado would have some sort of a response to what McClelland says here. But certainly what McClelland says, if there's videotape evidence and stuff, some of this stuff seems damning.
Yeah. It's a bit shocking to me that they would make claims about like timing and things like that when it could be disproven so easily. But frankly, again, I feel like it's echoes of the past all over again. Just seems to me like again and again there are these attempts to make things sound worse, but by doing so then it minimizes what actually is a concern, which is that I don't think he should be in prison. They should figure out something else for him, closer to his attorneys. But when you're putting in all this stuff that then is immediately debunked, it's like, okay, maybe just focus on what matters. Here's more information about life for defendant Richard Allen at Wabash Valley. McClelland knows that he has a tablet in his cell. He can communicate with his attorneys at any time through that. And he's had the tablet the whole time he's been there. There's also video conferencing that he has access to, so he can meet with counsel via video at any time. He has commissary in his cell. Notably, so commissary is where the inmates can purchase items, food, snacks, things like that. And he has it in his cell. The other people at Wabash Valley do not have that perk. McClelland claims, this is obviously a subjective statement, but that he is being treated far better than any other inmate in the Department of Correction. So the state has been making moves behind the scenes seemingly as well. Indicated that they spoke to Sheriff Dan Maher from Adams County. Adams County is one of the counties that Librado and Scriven were requesting that Allen be transferred to. It's in the northeastern portion of Indiana. It's on the border with Ohio. And so that with that one, Sheriff Dan Maher, he said he's not willing to take on Allen. He doesn't feel like he can accommodate him. He doesn't feel like he has the space. And they don't have any mental health professionals available to deal with the suicidal issues and mental health needs. So in addition, McClelland called up Sheriff Troy Hirschberger, who's the sheriff of Allen County, where of course that's Fort Wayne. That's where Scriven and Librado are from. He's willing to take him on. He's willing to take Allen, but there are caveats. The Allen County Jail is overcrowded. There would need to be special accommodations to house Allen, and there's no face-to-face visits allowed. You have to visit this person via video, and that includes attorney visits. So, I don't know, maybe he should just be moved to Allen County if they're willing to take him, but it sounds like there would be some drawbacks for defense based on that. Also, of course, now Allen County would be out of the way for Rosie and Baldwin, so that's probably neither here nor there.
So a very interesting response.
So generally the thing that McClelland is talking about is like will he get mental health help wherever he goes? And will they have the ability to accommodate him? Will they have the ability to have the manpower to keep him safe? And, what's the deal with the Carroll County Sheriff's Department? Do they have the manpower to make sure the transfer happens in a safe manner? So one thing that is an interesting aside from McClelland here, I think comes in point 39.
Which I will read. Once again, for the third time, the colorful, dramatic language used by the defense is an attempt to curry public favor for their client and try this matter in the public eye instead of in the courtroom, as has been a repetitive pattern in this case.
What do you make of that?
It seems very much an attempt to appeal to Judge Gull in particular, because I believe Judge Gull in particular has indicated she does not want this tried in the media. She wants it tried in the courtroom. So it feels like he's tailoring the argument for her.
Yes. And also it does speak to what has been indeed a recurring pattern between the defense and the prosecution in this case, where there's a lot of allegations made by defense attorneys about specifically his incarceration situation that then are maybe cast into some doubt by subsequent evidentiary hearings and legal filings. So I'll be curious to see how things end up going. And we should know that there's also 2 states exhibits. These are images of what appears to be a metal door with a slot in between, where I believe that is where documents can essentially be passed through to indicate what the setup was. It's a metal door. It's got like holes in it. It's almost like a grill pattern. And there's a large gap in between where there could be passing stuff. So that's that filing. Next is the state's motion to compel discovery.
And this is a much shorter filing. We've seen a lot of motions from the defense complaining about the prosecution not turning over discovery. Now we get one from the other side. This is McClelland saying that the defense has not been turning over what they should be turning over. And I'm going to read from it. Effective January 1st, 2024, the Indiana Supreme Court issued rules of criminal procedure, wherein Rule 2.5 discovery states that the parties must endeavor to share information without court involvement. Subsection C, disclosure by the defense, states that within 30 days after the prosecutor's disclosure, the defense must furnish the state with the following material and information within the defense's possession or control. A, the names and last known addresses of persons whom the defense intends to call as witnesses with their relevant written or recorded statements. The defense may refrain from providing a witness's address or other contact information under this rule if the defense in good faith believes the disclosure of the witness's address or other contact information may jeopardize the safety of the witness or the witness's immediate family. If the defense does not disclose the witness's address or other contact information in its possession for the reasons stated under this rule, then the defense must make the witness available to the state upon reasonable notice. B, any books, papers, documents, photographs, or tangible objects the defense intends to use as evidence. C, any reports or statements of experts made in connection with the particular case, including results of physical or mental examinations, and of scientific tests, experiments, or comparisons that may be used at a hearing or trial. 2. The defense must disclose any statutory defense in writing by the statutory deadline or if there is no statutory deadline within a reasonable time. To date, the defense has neither turned over any discovery nor have they provided the state with a list of expert witnesses that they intend to call at trial or any other pretrial hearing. So he's saying there's stuff they need to give us too, and that needs to happen.
I think some people might be confused because we often talk about discovery as far as prosecution giving everything to the defense. Does the defense have to give everything to the prosecution?
They don't have to give the prosecution everything, but there is this rule that just became effective on January 1st that they do have to give these particular items.
Okay.
So I guess the rule became effective January 1st, and Rosie and Baldwin have only been back on the case for a relatively short time. So I guess they're just putting them on notice. You guys need to give us this.
Okay. So there's been this all represents a flurry of activity in the Richard Allen case, and we'll be continuing to monitor what happens going forward. But I guess big takeaways are McClelland continues to push back hard on the defense attorney's characterization of Richard Allen's conditions and their concerns around that. And the defense team wants Judge Gull off the case, and they're going to push for that. So what will happen next, how things will be ruled upon, what the process for any of this is, remains to be seen. And we'll be, I guess, continuing to just follow it.
Thank you so much. Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.